gentlemen, good afternoon, my dear panelists. Thank you for honoring us on this IPR talk series. This is the third in the series. We started about 2 months ago. I mean, COVID made it possible for us to have things like this with people that are not even in Nigeria. We have about 3 or 4 people here that are not in Lagos or not even in Nigeria. So we thank you for coming on. Over the last 3 months, we've had 2, and this is the third one. The first one was generally on entertainment, and the second one was on publishing. And we had a big call out for the broadcasting code to look at it from the IP rights perspective. We have a very rich panel here. I will not go into introducing because we have a moderator. I'll pass it on to my partner, the principal partner of LNA Legal Consultants, Professor Adebambo Adewopo, SAN. Prof, over to you.
Thank you, our host. I welcome you again, everybody. I will give a brief intro to the webinar, and I will also introduce the panel before we proceed with the questions. In the last 2 decades, broadcasting in Nigeria has steadily emerged at the intersection of the traditional copyright industry and new media, and has remained a vital economic and cultural sector, which has always required adequate legal protection and regulation. This year, the new amendment, the 6th edition of the NBC Code, contains a bundle of provisions which strikes at the core of broadcasting and media rights, which is one of the most important pillars of the media industry. For example, Article 628 states, in the broad national interest, exclusivity of sporting rights in Nigeria is prohibited, unquote. In the same vein, the code prohibits broadcasters or licensees from entering into any form of broadcasting rights acquisitions, either in Nigeria or anywhere in the world, acquire any broadcasting rights in such a manner as to exclude persons, broadcasters, or licensee in Nigeria from sub-licensing the same, and in that regard, any agreement which have objective of preventing competition in the broadcasting industry is also foreclosed. Article 9, among other provisions. Like a thunderbolt, this provision or this declaration with the force of law has shaken the foundations of broadcasting regulation since the advent of pay TV in Nigeria. Indeed, since March, when it was first released by the National Broadcasting Commission, the controversy it has generated has raised a lot of questions bordering on the emerging regulatory regime for industry practices and standards relating particularly to acquisition of broadcast rights, generally, and with particular reference to premium content in the pay TV and video on demand market. As usual, the L&A webinar seeks to interrogate these issues arising from these provisions in the code from various perspectives as they affect the broadcasting and media industry in Nigeria. The webinar will explore a whole range of questions with a view to decoding this controversial broadcasting code. These questions includes, for instance, as this new amendment code ushered a new regime, a new regulatory regime in the broadcasting industry in Nigeria. What are the ramifications of this exclusivity provision in the code? What does it portend for the content industry? Is this justifiable? Is it negotiable? How will the regulation satisfy market dynamics? How will market dynamics meet the imperatives of public or national interest? What are the intellectual property, competition, and public policy implications? What way forward? These and many more questions our eminent panel will answer in this webinar. To do this, once again, L&A presents another rich blend of experts to help us unpack or deconstruct this loaded code from various expert perspectives. Please permit me to introduce the panel one by one. The first is Mr. Tunde Irekora, a legal practitioner, regulator, and administrator. Mr. Irekora has practiced law for almost 30 years. In addition to being called to the Nigerian bar, he was also admitted to practice law at the Washington State Supreme Court. His vast experience ranges from being in-house counsel to general counsel, managing partner of a leading law firm, and at various times has advised private and government institutions in diverse areas of law, including commercial transactions and litigation, civil rights, regulatory functions, among others. His record of advocacy and representation in competition and consumer issues has been exceptional. He's currently the CEO, the Vice Chairman, and the Director General of the Federal Competition and Consumer Protection Commission. The next is no other person than our own Mr. Guy Murray-Bruce, a broadcaster and media executive. Guy did not spare any time after graduating with a business administration degree from California State University in 1985 before plunging himself into the waiting waters of the Nigerian entertainment and media industry, where he has carved a niche for himself in the last 28 years. From being vice president, Silverbird Group, 28 years ago, to taking charge as a group president 10 years ago, and responsible for both the local and international operations of Silverbird Group with extensive portfolios ranging from cinemas to communications across Nigeria, Ghana, Liberia. Guy is unarguably one of the leading lights and indeed a captain of the media industry. After having served as secretary since 2013, Guy is currently elected chairman of the Independent Broadcasters Association of Nigeria, IBAN, an important and unique role at the core of the broadcasting industry in Nigeria. Of course, we have Mr. Emeka Mba, who is a complete media executive, regulator, administrator, and creative entrepreneur. He is an encyclopedia of everything media, having served in various capacities at both private and public sector in the media and film industry in this country. He has about 30 years experience in the convergence of media, entertainment, and technology. It is only Mr. Mba who holds the unique privilege of having served in two separate chief executive capacities in the film and media industry in Nigeria. He was Director General, National Film Video Censors Board, and he also served as Director General, National Broadcasting Commission. As a broadcaster, broadcasting regulator, he laid the foundation for the new national digital ecosystem and the transition from analog to digital television in Nigeria. Of course, we have our own Dr. Nkem Intayi, who is evidently one of the emerging intellectual property scholarly voices in this country. She holds her degrees from Obafemi Awolowo University, University College London, and currently a doctoral researcher at Queen's University, Belfast. She has published widely and a frequent speaker in IP conferences and seminars in Nigeria and outside. She currently teaches IP and commercial law at the Faculty of Law, University of Nigeria. We have our guests From Europe, Ms. Jade Kolitakis, who is an IP lawyer with focus in public law and regulation. She joined the Faculty of Law, Abertay University in Scotland in 2017. And prior to that, she held positions at the University of Western Cape and University of Cape Town in South Africa. She's a frequent speaker and contributor to debates around South African IP and innovation ecosystem. Last but not the least is our own Ayoyemi Lawa Arolo, who is currently the professor at the School of Law and Security Studies, Babcock University. Yemi has lived and studied across 3 continents. She holds a PhD of Kent, University of Canterbury, United Kingdom. She was one of the pioneer staff at the Nigerian Copyright Institute, a research and training arm of the Nigerian Copyright Commission, while an adjunct lecturer at the Faculty of Law of Nassau State University. She has several years of teaching, research, and consulting experience in the field of intellectual property rights and knowledge system. She is a partner currently at L&A and the head of research of the firm. Now, let us go straight into the proceedings. And of course, I will start with Mr. Emekamba to give us, to unpack this whole issue with the with the overview of the broadcasting ecosystem, the regulatory framework, the role of NBC, the role of the code, the advances in digital technology, the new media. Just give us a brief background just before I go to Mr. Guy Murray-Bruce, who will take it from there. So, Mr. Emekamba, give us a brief outlook of the entire broadcasting and media industry in Nigeria, with particular reference to the regulatory framework that we have presently.
Well, thank you very much, Prof. It's a pleasure to be on this panel. It's such an eminent array of scholars and researchers and lawyers and so on. It's a privilege. You know, to the heart of the matter about the background, as you know, broadcasting is uniquely essential in any country, and more so, I always like to sort of reference this analogy that if information and media is for entertainment in Europe and in more developed societies, in our context, it's often a matter of life and death, because we need more information, not less, and that's critical. That's that basic understanding has to be there. The other thing, can you hear me?
Yes.
Okay.
Yes.
The other thing that I also think is important is to understand how we've moved quite quickly from in the early 90s, General Babangida's regime, setting up the Broadcasting Commission, and how under the leadership of Dr. Adaba, how that the commission was set up to sort of guide broadcasters into the private broadcasting ecosystem that we have today. So it's the NBC is integral, and the NBC has done extremely well in any way you look at it, from not just from helping to put the framework in place to make private broadcasting successful, at least to where we are today. But the idea of the code is, for me, very integral, because you cannot have broadcasting without having a sort of set of guidelines that will, sort of put people in check. But the idea of the code itself, and it goes back to the fact that I think it has its roots in an element of what you might call some form of self-regulation or co-regulation with the regulator, because it's a code of practice that everyone has agreed to, and that's usually why it goes through a process every 4 years at least, to gather everybody in the industry together to sit down and look at the issues. But one thing that's critical to understanding what's going on in industry is that we are in a digital space now. And I always say to people, you need to understand that digital is not, it's not a revolution. It's a constant evolution. It's a constant stream of changes, because, today, many years ago, if you were old enough like me, you remember that you had to go at 4:00, NTA will come on, and we all sat around those old TV sets, and so there was an idea that you had one broadcaster, or at least a handful of broadcasters. But today, pretty much anyone with a cell phone connected to the internet and has a camera can become a broadcaster of sorts. So the idea is that this new digital ecosystem is completely changed how we do business. The new business models have been formed. You talked about in your intro, video on demand services, OTT services, all delivering service in this market. And to a large extent, that has sort of changed the game from the concept of where we started many years ago. So by and large, and I think I like to make this point, that the NBC, and as most other regulatory bodies in Nigeria, they were framed with a scarcity mentality, with a concept of that these were scarce resources. You were using frequency or spectrum that were scarce, and now we've moved beyond that to, for example, satellite broadcasters are not resource dependent. They do not require the resource of actual capacity from the government or from the NBC, for example, to do their business. So I think the point that I'm trying to make is that in this rapidly dynamic environment which broadcasting is situated in, because broadcasting and, in fact, entertainment generally is really at the nexus of technology and law. It's more than any other, perhaps maybe only health, but it's really situated at that nexus where it constantly utilizes technology in terms of how it uses it to reach people, and how people use it, consumers use it to access content. And the issue of, as what you said, looking at the NBC, the new NBC code, how that has actually reached, in some respect, some kind of overreach into copyright, into consumer issues, into competition issues, and whether that itself, whether that whole piece of legislation, have they really thought about it? Because I often say, what is the extent of, what is the intendment of a piece of legislation or a piece of regulation? What is it supposed to achieve? Has it been clearly defined? And my own mantra as a regulator has always been that if I cannot define something, or at least define what business model, what impact, I should be very wary of intervening until I understand it, which is why I'm glad that Mr. Rukere is here. And I'm not saying it because it's on the panel, but he has a way of, if you look at his last post around pricing in the pay TV market, he's opted to study it. Let's understand it. Let's know what are the elements, what's going on before you make an intervention. I think these are very critical tools because, as I said, digital and the broadcasting space is moving, is very dynamic. You cannot have a mindset that is born out of a scarcity mentality, born out of analog, to try and regulate a space which is moving, which is very dynamic. And that's why I always say, let's understand the context first of all. And I will say that even in terms of the definition of what the NBC has set forth, what do they mean by premium content? Is there a definition of what premium content is? Is it sport? What kind of sport? Is it local sport? Is it foreign sport? Is it movies? What kind of movies? So all of these things require, clear thinking, and not just the intent that often follows regulators, not just in Nigeria, but across Africa. And I have been, I've been like that as well, to often fall under the pressure of saying, oh, we need to do something. My point of view as a regulator, that sometimes not doing something is something enough, because there's always that temptation that, oh, something is going on. Without understanding it, you rush into, let me take a decision because of political pressure or some other thing. But sometimes just studying it, there's a value, there's plenty of value in understanding what is the value chain? What is the new broadcasting value chain? What is it? What are the different components? And I think I just thought I sort of framed this here. But by and large, I think the intendment may be noble. The process, I find some faults with it because I don't think it was well thought out. I'll just leave it at this point.
Yeah, excellent. Thank you. I mean, we're really going to come back to you on this. We're just trying to build up here. Mr. Guy Murray-Bruce, you are a broadcaster. You are right at the heart of the matter. You are chairman of IBAN, which is really, really very powerful group in the private sector broadcasting in Nigeria. What's the role of your organization? Let's start with that. Generally, and with specific reference to the successive broadcasting codes since 1993, 94, thereabout. So what has been your role in this regard? How did you receive this particular code in question? Let's start with that for now.
Thank you very much, Prof. As you rightly pointed out, broadcasters ought to be at the core of the formulation of broadcast regulations. However, in Nigeria, a paradigm set in an analog age where the electronic media was a vital component in the execution of military coups still forms the basis of regulation. This is what you get. The world has moved away from relying on traditional electronic broadcasting for the regulating of socio-political conduct. Back then, the media, especially in Africa and most of the developing world, was run by governments with a mandate to affect the psyche of the populace in the direction the government of the day deems appropriate. Today, independent broadcasting is more interested in the entertainment of audiences and not propaganda. That is not to say that the ownership of some broadcasters don't have political agenda, but in the long run, the profit motive overrides the political motive. The fact that the regulators have not adjusted their mindsets to this reality and moved from the gatekeeper mentality is what accounts for their reluctance to fully integrate independent broadcasters in the process of formulating regulations. BON, that's the Broadcasting Organization of Nigeria, has inherited some of these DNA traits at its formation when its membership was exclusive to state-owned media. That's NTA, FRCN, and the state TV stations. By the time independent broadcasters were admitted, one would have expected that an adjustment in thinking would occur, especially as the number of independents now outstrip state-owned broadcasters. Just for you to know, there are 70 federal and there were 107 TV stations owned by the federal and state, that's NTA and the state governments. And there are 304 privately owned radio stations in Nigeria and 61 privately owned TV stations. So as you can see, there's a big gap now. We have more independent TV stations and radio stations. Then you have federal government TV stations and radio stations. To a large extent, BON is seen by governments as a parastatal created to put all broadcasts in check, or at best, malleable. The formation of IBAN since 2001 was a necessary response to the issue as they stood then. For instance, we recently issued a statement insisting that the recent amendments to the 6th Broadcasting Code didn't have enough stakeholder engagement. Oh, my computer is showing me a different story here. I don't know. Thank you. Okay. They didn't have enough stakeholder engagements before being announced the feedback we've gotten from NBC indicates that they are beginning to see the advantage if engaging us more closely. Basically, yes, the amendment came out, Emeka said it right. The intent is good, but the process could be worked upon. We independent broadcasters weren't carried along as we ought to, because as you can see, we're a majority here in this media space, and most of us were not carried along, and we faulted a lot of things there, and we ought to bring NBC. NBC needs to bring us to the round table to discuss it further. Maybe an amendment to the amendment. I don't know. Emeka, you were the DG. How does that work?
All right. Thank you so much. Excellent. Mr. Tunde Erokera, you know, this is where we need you here. The code, in very clear and unmistakable terms, enunciated is wider public interests and indeed competition objectives. In fact, there's a whole section that is titled anti-competition in that code. And this is where you come in. Now, with particular reference to the exclusivity clause, which is perhaps one of the most controversial provisions in that code in relation to content acquisition, what is your perspective as a regulator in the competition space in Nigeria?
Good morning, all. Thank you very much for inviting me. I'd hope I would speak much later. That way I would have been able to gather knowledge from everybody and appeared a little smarter than I really am. But you put me on the spot far earlier. And so competition analysis cut many, many ways. And as simple as it may sound, it's actually very complex. And a competition regulator must recognize exactly what it's trying to do with competition. And the first challenge sector regulators always encounter when discussing things like consumer protection or competition is the fine line, maintaining the balance between what really are the rights of people who are their licensees and the rights of people who are subscribers to those licensees. And so there's an inherent potential conflict. And so the reason why competition regulation, overall competition regulation, sometimes is usually independent of the sectors, is exactly that potential for inherent conflict. And because the complexities required are such that sometimes a sector regulator could be blindsided. But having said that, listening to everyone else and from what I know, I think we all agree that competition is a good thing. And our analysis of competition as a competition regulator is purely from the market. Business-to-business regulation is also for the benefit of the market. And the key reasons for competition is to ensure that there's a level playing field, that everyone can know barriers to entry, and that there are no abuses of market power in any way, so that ultimately consumers can get the benefit of fair pricing, quality, innovation, and choice. That's basically, from a principle standpoint, that's what it is. It might be more complex when you slice it. And so one of the key things that generally adversely affect competition is exclusivity. And so Section 59 of the Federal Competition and Consumer Protection Act prohibits restrictive clauses and restrictive agreements, essentially potentially targeting exclusivity. But the entire competition framework also recognizes that exclusivity sometimes is part of business. And one of the key issues in competition is innovation. And one of the things that promotes innovation is some level of exclusivity, whether it's in drug manufacturing, because usually people make a large investment in research and development. And so there's usually a time period where you can take the full benefit of your intellectual property and to recoup your investment before it becomes generic. And that's not just an example, not necessarily something that is certainly the case in the media. In the media, it's significantly different. because a lot of content has to do with individual creativity that are protected by intellectual creativity rights. And so any discussion about exclusivity in the media or in any sector for that matter must take the sector as you find it, understand exactly how that sector operates, and then define the scope, the objective of the regulation, and the framework of that regulation based on how that sector operates. Certainly, the NBC is a sector regulator, and not only does it have the powers, it actually has the obligation to manage and regulate the sector in the fairest possible way. And managing competition within the sector is certainly one of those key functions of the NBC. And it is not inconsistent with the overall competition principle or policy of the country, or generally globally, to want to manage exclusivity. However, the way we would look at it from a market standpoint is to look and see how does any proposed regulatory framework affect the market. And you must make sure that what you're doing in itself does not become counterproductive, as it is quite possible in competition regulation. For instance, price regulation by its very nature is a very powerful consumer protection and even competition tool. But misused or abused, it's also the exact framework to discourage competition, remove innovation, and make quality of services or goods poor. And so those are the key issues we must consider. And one of the ways that, one of the global answers to exclusivity has always been open, transparent opportunity. And so, for instance, if there is a bidding process, to the extent that that bidding process is open, it's very transparent, and it's fair, in itself, it's usually a first response. And it's usually a first place we would go as regulators to see if there's a fairness in the market. And we have other tools. And so generally our regulation of exclusivity when intellectual property is involved or bidding is involved may not necessarily be democratizing what really are people's intellectual rights. It would be to look behind that process. And so, for instance, if there were multiple parties that were bidding, we want to see if there is some kind of coordinated conduct between the parties to rig the bids. Or we want to see if a party is able to leverage resources that would put it in an unusual advantage over the other. And that happens a lot when you're dealing with multinationals or companies that have some kind of vertical integration where they're able to pull on the resources of others within the group. And so we would analyze those very closely. But our first call will not necessarily be to democratize what really are rights that could ultimately promote anti-competitive conduct. But again, like I said, that's a general approach. Industry would still adopt an approach that works for it. But one thing that I must note, and which NBC was going to have to look very carefully at, because we would look at that for sure, is one, when you democratize secondary level privileges, sometimes when that process is not well done, what you might potentially do is discourage competition, because many people would not put their best foot forward. They won't send their first 11 to the field and wait, knowing that it doesn't matter how this is going to play out. I'm going to get my piece of it. And many times when a dominant operator in any field does something, especially with things like moving prices, the real problem is not even necessarily that dominant operator. And so take, for instance, using aviation as an example, you've got two airlines that fly between Lagos and New York. One gives premium service, good in-flight entertainment, hot meal. The other, no in-flight entertainment, no hot meal. You just sit in the aircraft, doesn't arrive on time, no seat reclining, nothing. And of course, so this other one is dominant. The one that provides the additional services is dominant because most people go fly it. And so it can control pricing to some extent. And so let's imagine that now that dominant one adds additional value, says, I'll give all my passengers pick up to the airport, separate check-in lines, and then drop off when they arrive at their destination. And in exchange for that, I'm going to increase the fare. And so it's quite possible that there's a reasonable understanding and there's reasonable value for the increase in fare. But maybe 25% of your passengers cannot afford that anymore. They're going to fall off. And they're going to fall into the hands of this other airline that provides no hot food, no in-flight entertainment, nothing. And so that other airline, because you've moved prices, is now able to move prices also. You moved prices because you added value, but someone who didn't add value but is reaping from your movement is now able to exploit. And so those are key things that we would look at when you're looking at secondary level licensing and privileges allocation. We want to make sure that those people who just wait and do not operate at the primary level but enter at the secondary level are not the ones who end up abusing or exploiting consumers or the market in many ways. And the other thing is we also want to make sure the market operates in an optimal manner to the point where there is ultimately no discouragement to some to pursue innovation and to make investment. Because ultimately, when that happens also, it would affect the market negatively. And so we always want to look at all the different pieces, and we will be looking at the different pieces even in this industry. This particular industry is a very tricky one because there's dominance. We understand the objective, we encourage and agree that we must make sure that market entry in this industry becomes something that is easier, and any abuse of dominance always is a restraint to entry. And we must look at whatever it takes, but we can look at it by broad strokes. We would look at it piece by piece and unlock each screw. And we just must come to the table and work together on it. But one thing is clear. There is element of significant dissatisfaction from a value for money proposition in the industry. And we've got to address that one way or the other. However, the way to address it will not be to discourage competition. Thank you.
Wow, excellent. Thank you. Thank you, Mr. Erokera, for those perspectives. Now, Dr. Inkem, we are zeroing in gradually because we've had mention of intellectual property rights, copyrights, and all of that, with particular reference to the exclusivity clause, which has been prohibited by this code. From strictly intellectual property perspective, just before you go into comparative analysis, give us a sense of the implications of these provisions, these exclusivity provisions for broadcasters from intellectual property rights perspective of the broadcasters.
Thank you very much, Prof, and thank you for having me here today. Strictly from intellectual property perspective, what I would say is that when you talk about content and ownership, it is clear in our Nigerian Copyright Act that a film, for example, is a work that is eligible for copyright protection with the producer generally as the owner of that work. Now, this new NBC code under Article 9, specifically Article 9118, has said that it will compel sub-licensing when the genre of programs enjoys compelling viewership by Nigerians. Now, this phrase, compelling viewership, has not been defined. However, what I will say that this Article 9 is contrary to the exclusive protection that copyright offers. Now, Section 10 of our Nigerian Copyright Act allows content producers to license their products either partially or exclusively And so the Nigerian Copyright Act allows a content producer to grant exclusive license to any distributor of his choice. And thus, what I would say is that NBC really has no legal right to determine who should acquire rights to such content. Now, the question generally on the IPRs is that what Article 9 is saying, is it therefore not an infringement on the rights of the producer if the NBC says broadcasters cannot acquire exclusive content? This is a question we must answer in legal terms. Now, independent producers should be encouraged and given an enabling environment to maximize returns on their investments. Like in other climes, well, you don't want me to go into comparative right now, but I'll just say this generally. In other climes like the United Kingdom, they are giving tax relief where there's a theoretical release of film, and as much as 10% or even as much as 80% in some instances, and they're giving up to 25% tax rebate for release of movies. There's no such rebate in Nigeria. So we are saying, based on our law as it stands, this Article 9 is an infringement of an owner or ownership of a copyright work, and they should be given free will to do their work as they will. That's the owner or the producer in Nigeria. Thank you.
Wow, thank you. Now, Jade, give us a bit of comparative perspective following from Inkem's starting point, from the South African perspective, from the United Kingdom perspective of the broadcasting law. How has the existing law or legal framework in those climes regulated broadcasters' freedom in the acquisition of broadcasting rights across content?
Okay, well, thank you very much for having me. Interestingly, in South Africa, we're also going through a really big watershed moment right now when it comes to broadcasting and copyright exclusivity, particularly around sporting content. So in South Africa, copyright owners control broadcasting rights to their property. This is protected in the Copyright Act of 1978. However, the Independent Communications Authority, or ICASA, who is the official regulator of South African broadcasting and telecommunications, is proposing to introduce new regulations which will, as in the case in Nigeria, preclude exclusive licensing agreements for popular sporting content. So this is not unlike the amendments to the code, which state that in the broad national interest, exclusivity of sporting rights in Nigeria is prohibited. There have already been public consultations held on these draft regulations, and pretty much everybody is against them. And interestingly, this includes, at least in part, South Africa's free-to-air broadcaster, their primary free-to-air broadcaster, the SABC, or South African Broadcasting Corporation. Now, the issues with South Africa's proposed regulations are not unlike some that have already been raised here with regards to Nigeria. They are inherently anti-competitive by prohibiting exclusive licensing. It doesn't incentivize free-to-air broadcasters to acquire these rights. What it does is it disincentivizes subscription broadcasters from paying premium prices for premium content. And when subscription broadcasters pay less for these rights, it means that the national federations make less money. And this has far wider implications for the South African population and the economy as a whole, not just implications for people involved in sport. For example, national federations such as the South African Rugby Union or South African Football Association make on average anything between 50 and 80% of their revenue from exclusively licensing these broadcasting rights. And a significant amount of that money goes back into further developing objectives that benefit the local community, and it benefits the sport in particular, developing that sport in South Africa and the people of South Africa as a whole. For example, the Premier Soccer League generated 64% of its revenue in 2018 from the sale of its exclusive broadcasting rights to MultiChoice, a subscription broadcaster in South Africa. This meant that because of the revenue gained, they were able to increase monthly grants to the highest divisions of the Football League and make South African football more competitive than it's been in many years. It also meant that they were able to invest in township communities and the communities who are the poorest in South Africa, giving those people opportunities which they would not otherwise have. Lastly, the policy aims, as was previously stated, whilst the policy aims are not necessarily bad, there are other ways in which they could be achieved, which both upholds IP rights and enhances broadcast competitiveness. For example, ICASA could decide instead to unbundle the rights to these sportcasting events. And that would mean, for example, one broadcaster can buy exclusive licensings to air these events on the radio, another can buy an exclusive license to live stream it on the internet, so on and so forth. In addition, these licenses could be further regulated by ICASA, for example, doing away with automatic renewal clauses or prohibiting the duration of an exclusive license that could be mandated through regulations. So there are opportunities to balance these two things. In the United Kingdom, you have the Broadcasting Act of 1996, which restricts the acquisition by television program providers of exclusive rights to live television coverage of listed events. And these are generally events in the national interest. And you can only acquire exclusive rights in these events if you first obtain consent from Ofcom, or the Office of Communications. Now, it's worth noting that Ofcom has been very generous in allowing these permissions to be granted. For example, Ofcom gave its consent to a request from Sky UK, a subscription broadcaster, to broadcast exclusive live coverage of the International Cricket Council's 2014 World Cup. And cricket is obviously one of the sports most closely associated with the United Kingdom. So, yeah.
Excellent. Thank you for that. Now, Prof, help us tie all of this together. The questions have started coming in. After Prof, I will come back to Emeka to give us some more information on the background. But Prof, tie all this together. We have a whole lot of issues on the table right now. Industry perspective, regulatory perspective, competition perspective, comparative perspective, IP perspective. Can you just summarize all this preparatory to take questions from our attendees?
Okay. Thank you, Prof. I've not been able to stop smiling since it started with what everybody has been able to say. So I'm going to start with you, Prof. You said it strikes the core of broadcast rights. It does, definitely strikes the core. And Mr. Emeka Imba said overreached into copyright. So it too goes along. That is what it has done. Exclusive rights, private rights. It's gone beyond its limits into going into copyright issues, regardless. Start taking into consideration the rights of these people. So you buy a house, somebody tell you how to list it, how to sell it. Now use this word, thunderbolt, controversies. People reacted immediately. What is going on here? So again, I like that word. Is it justiciable, you asked? No. Is it negotiable? Yes. Jade just talked about the UK. Inkem talked about Nigeria and the UK. And Inkem did not mean words at all. She gave it, no, you can't do this. You know, they have exclusive rights. They cannot exclude the word preclude and all that. So Inkem said it, Jade has said it now. I was going to go a bit into the UK as well, that you have a window for negotiation. You look at the stakeholders. You look at what you intend to do. Intentions really matter. Again, Mr. Imba talked about intentions. Intentions of the regulators really matter. What exactly do you want? Okay, you want competition, but you want to stifle competition as well? You have to think about it. It's not about the policy or the law, like Jade said. It's about how you go about it. What is the process? Do you give respect to the rights of creators or those who go so far in investing in getting films and movies and then broadcasting it, and what they've gone through, efforts, labor, copyright, reward, and all that. So all those things need to look at. So the process, the fault is in the process. Someone said that again. I agree that the fault is in the process. Again, I'm going to go to Mr. Guy Moribus. He said public motive over political motive. True, very true. You're going to look at the Nigerian environment. What do we need? What do we want? What exactly is going on? No one says there shouldn't be competition. I sometimes use this, that corporate is not saying you can't have 15 types of Cinderella, but you can't copy the original Cinderella movie. So you have Cinderella disco dancer, you have Cinderella black boy, you have Cinderella this, Cinderella that, but don't copy. That's what it's saying. Don't copy, but be creative about what you want to do and what you want to put out there. So a lot of people have to work hard to get what they need to broadcast out there. Now deciding to just say, we'll tell you what to do with your private rights or your exclusive rights without a negotiation. Like Jed said, you have this event list. They come together. This is what is going to be on it. It is usually looked at and updated, or more is added, or some are taken away. You have to create a negotiation table for those who have exclusive rights over their copyright and all that. She talked about South African football competition. I'm thinking Nigerian football. A lot of people are more concerned about watching international. I don't do football, but I know people are more about the European leagues and the different kinds of football you find out there. How really are we trying to develop local content? Most people are not really interested in local content anymore. Why? Because NBC should do something about that. Are you going to hear it more? What is going on out there? What is happening? Should you broadcast it more? Should it go further than it is? What are we doing about what we have locally? What we have locally has to be developed. And then what we get internationally should not be stifled, because that will not be the way to ensure that there's competition. You have to negotiate. There has to be a negotiation board. And thank you so much, Mr. Tunde Rukere, as well. Yes, definitely. You shouldn't kill competition, but at the same time, we should respect and take into consideration other people's intellectual property or copyrights. Thank you.
Excellent. Thank you very much. Now, back to Emeka. Do we have in our hands a challenge of regulation? I would like you to speak to that, because in your comment, you talked about intent, you talked about process, and other issues in the making of this particular amendment to the 6th edition of the code. Do we have a challenge of regulation here? And if so, how do we resolve it? What kind of challenge is this, from your experience, both as a practitioner and as a regulator?
Well, I clearly think that we have a challenge of regulation. And it stems from a mindset deficit, a mindset challenge, first of all. As Guy said, Guy gave a background. I try to be a bit more diplomatic in my own contextualizing the issues, but Guy was a bit more blunt. You have a regulator, you have a regulatory mindset, as I said, formed from a different era that served a different purpose, and now things have changed. And not just that things have changed, the change is constantly happening as we speak. So one of the challenges that regulators, especially in our sector, in the entertainment or in the broadcast, in the media sector, were challenged because of the dynamic nature of change in broadcasting per se. Look at OTT services. I mean, I give you a little bit of my own faux pas many years ago. Whilst you and I were in service, we had this thing of distribution of Nollywood movies. We were going to stop it by saying you needed a license to take Nigerian movies outside of Nigeria. It sounded very well noble, very well, people clapped for us. But in reality, someone can take a flash drive, put Jennifer's story, put 10 movies on a flash drive and take it abroad and then have it distributed abroad. So even though we claimed we were doing something, but if you understand the value chain of an industry, you're much better able to regulate that industry. So there's a lot that needs to be done for regulators to catch up, and not catch up from, because you cannot tame technology, but catch up from simply opening your mind to understanding. I mean, if you go to the GSM, in the GSM world, in telecommunications, they use more ex post interventions rather than using more anti regulation. So we're sitting in a situation, as I said, where let's imagine that you see even, okay, let me go back a little bit to what Mr. Ruker talked about. If you look at broadcasting, there are 3 levels to broadcasting, three fundamental levels, and the first one is really the issue of the packaging of the. So where is the bottleneck? Is a bottleneck in terms of the access to the bidding? Is it the bottleneck in the access to acquisition of the content? Is the bottleneck in terms of where the content is packaged and retailed to consumers? Is a bottleneck in terms of the delivery of the content, that is my having access to the EPG, for example, of a dominant operator, and so on. So where is the bottleneck? And when you look at that piece of regulation, it didn't address all of those things. There were clearly the definitions where there's kind of schemed over regulations, because it requires, and this is the challenge, and I say this from my own point of view, we often do not pay attention to rigor, to analysis, to impact assessment, to understanding. Yes, this sounds good on paper, but what is the intendment? What will it do? Because I can intend that I want to do this, is good for the industry. But actually, when I start doing it, it will cause more problems for the industry. So all of this analysis is really lacking. But to answer your question quite bluntly, we have a regulatory deficit. And so I'm always, and I'm not saying it because I'm on the same panel with Mr. Ruker at the FCC, but just reading some of the public notices. So sometimes you even do an intention to rulemaking. We intend to do this. This is what we want. This is how we want. You call for papers, you call for document, then you sit down with people and you review it. So all of those things are a bit fudgy in our market. But like I said, I think that regulators need more education, need more knowledge, not just sectoral knowledge, but broad knowledge.
Wow, thank you. There's a question here from Mr. Erukera, but before I shoot that question, I would like Mr. Guy to intervene here. I mean, he is really at the core of this discussion. How is the pay TV market like? How is it going to be affected by this provision? From broadcasters' perspective and from your vast experience, what is the precise implication of this exclusivity provision to your operation as a broadcaster? Is there any likelihood, for example, that millions of football fans who are ready to pay to watch live matches may not be able to do so in the light of this provision? The same for movie channels. So give us a sense of how this is going to really play out in the industry.
Thank you very much, Prof. I like what Emeka said. There's a regulatory deficit. Those are 2 powerful words. Let me quote from the preamble to what I consider the most contentious segments of the amendments. That is, in the broad national interest, exclusivity of sporting rights in Nigeria is prohibited. That's in section 6.2.8 of amendments of the 6th edition of the Nigeria's Broadcasting Code. How the right to view as a live sporting event equates with national interest is beyond me. The regulation goes on to state, and I quote, "A right owner to live foreign sporting events shall offer the rights to broadcasters on the different platforms stated. This effectively priced exclusivity from the grasp of companies that pay millions of dollars for them. How that is fair in a national interest is questionable. Is it conceivable that the NBC, the industry regulator, is unaware of the economics and mechanics of this business? From all indications, this amendment appears to be targeted at emasculating a particular company. What, however, is not clear is on whose behalf this is being done, because as it stands, there are probably only 2 companies that have the capacity to acquire premium foreign sporting rights, one of which is a partnership with a public broadcaster. When a regulation has such a narrow focus, that is to say, a similar regulation cannot be made to cater to a future yet to be determined narrow interest. As chairman of IBAN, no member that I know has complained about the exclusivity of the rights to premium sporting content held by a particular company. That is why I wonder whose benefit this amendment was crafted. The implication of this regulation is that NBC is seeking to interfere with international commercial transactions and contracts. This might adversely affect the cost of such rights acquisitions, which are in hard currency, and subsequently the capacity to acquire them, thereby denying the existing viewers the benefits of live premium sporting events. This clause is clearly an overreach and should be critically reviewed. As broadcasters, we would love to have access to premium sports entertainment, but we recognize the importance of respecting commercial contracts. I also find funny an aspect of the amendments requiring that broadcasters, and by extension advertisers, should compulsorily acquire local sporting content at a minimum of 30% of the value of whatever is paid for the equivalent foreign sport content. As the bulk of funds for the acquisition of premium sports content comes from advertisers, this clause accounts to dictating to brands how to deploy their marketing budgets. I'm not sure this is practicable or proper. My reading of the regulations indicate that the same fate may be extended to video on demand movie channels who expend considerable amounts to produce exclusive content. This regulation has the potential of stunting the development of this emerging segment of the industry. I really think the entire code and amendments be put on hold and a broader stakeholder forum be convened to straighten out these knotty issues. So basically, I like quoting America, regulatory deficit. So if for some reason X company goes to get acquire rights to Premiership League, pays millions of dollars, he now has to get the company that sponsors them to go pay for local content. It might not be in the interest of the company to pay for local content, or vice versa. You can't compel a sponsor what to do. It's their right to do whatever they do. They want to have global reach versus national reach. It's something that we have to debate, and there's a big flaw there. Thank you very much.
All right, thank you. Mr. Rukere, I have to read these questions out. Actually, there are 2 questions for you, but I'll take one for now. Then when we're going to another round, looks like you're the first to be responding to some of these questions. There's another question on IP, and I'm going to come to Jade, to Inkem, and to Prof with that question. The question for Mr. Rukere is this: is the broadcasting code in conflict with the FCCPC Act in its specific prohibition of broadcasting rights acquisition agreement that contains no sub-licensing clause, which isn't per se prohibition under the FCCPC? So it talks about the relation between FCCP Act and the code. What's your view on this?
Well, and this is such an important question, not just because of the code, but really because of the whole broad spectrum. Literally everything we regulate at the FCCPC has somebody else regulating it in sectors. And so there's really, the good thing about those who worked on the FCCPA is that they foresaw a lot of this, and the way that the law is crafted addresses all of this. So there's no real adversarial conflict for want of better language, between the law, because the FCCPA already says one. First, the FCCPC must enforce any and all enactments for the purpose of protecting consumers or for competition. Secondly, it's section 104 says where there is a lack of clarity or apparent conflict between the FCCPA and any other law for that matter, or certainly any subsidiary legislation, then such would be read as modified by the FCCPA. Then section 163 even says that other laws, whether it's the Securities and Exchange Act, obviously the Broadcasting Act or the Code or anything, will be read in conformity with the FCCPA. And that's fine. And that's really how it operates everywhere else in the world. And so, for instance, the FCCPC has a responsibility to determine even dominance thresholds. And so the way we would determine those dominance thresholds is to talk with everybody. Because once we determine a dominance threshold, it would override whatever sector thresholds have been set. And so I'm not concerned. The answer to that question is I'm not concerned about what seems to be a conflict. And in any case, just from the rules of interpreting legislation, it's difficult for a code, which is a regulation, to be in conflict with an act, regardless of what the space is, unless it is a code that is made pursuant to an exclusive jurisdiction of an act. And so we're not worried at all. And I think that ultimately the way the market would play out would, when everything settles, we'll see that there would be some alignment between the NBC and the FCCPC. Right now, I can say that from a formal and from a policy and approach standpoint, we have not come to an impasse. We do not have a conflict. We don't disagree on any rules of interpretation yet. Now, that could also be in part because these are the early days, but I also think it's also in part because we've adopted a very broad approach to interpretation and alignment. And I think that that alignment will emerge.
Okay, thank you. I'll let Dr. Inkem take a shot at this question first before Jade, then Prof will, it's basically on IP effect of the code. Can the new code, the NBC code, be said to be depriving copyright owners of its exclusive rights? Or, and this is very important, there's a fine distinction in this question. He said, does it deprive the copyright owners of its exclusive rights, or merely regulating how that right is enjoyed? And I think this is a very fine distinction. I don't know whether you got that question. Whether the code is said to be depriving the owners of its exclusive right, or is the code merely regulating how that right is enjoyed?
Okay.
Yes, Dr.
Thank you for that question. This question actually brings about the nuances in Nigeria. We cannot really take the case in Nigeria and compare it side by side equally with what happens in other jurisdictions. And this actually brings into the question of the issue of windowing. All right, windowing has been defined as the process of managing the release sequence for content so as to maximize returns from intellectual property rights. And it's a key factor, we agree, that drives contract and negotiations. However, these NBC code amendments, if you compare it strictly with the law, it's, I would say, it should not take the general look as a whole, but compare it with the nuances in Nigeria. Now, the likes of Netflix and Africa Magic have used this issue of exclusivity as their business model. They have invested a lot into the exclusive original content from local movie producers in Nigeria. And they may not be required to license that exclusive content to other broadcast media in Nigeria. And they may not be able to enter into exclusive deal in their contracts. Now, this exclusivity is what's favorable to producers. They will rather cash in because of the nuances in Nigeria, top of which is piracy. Now, if we say it's only regulating, it may stifle business investment in the Nigerian creative sector, and it may impede further direct investment. I would say that instead of an outright prohibition, what they could do is to adopt what has been done in Europe, where they take each case on a case-by-case analysis. Now, each windowing case will be scrutinized and to check whether there are anti-competitive effects. And if it so happens there is, then they can go on and put this to place. But to make an outright prohibition of windowing will not really take into cognizance Nigerians' developmental stage, especially in the creative sector. Thank you.
Jade, can you take a shot at that?
Yeah, so...
Will I repeat the question? Do you have the question?
No, please repeat it.
Okay, the question is, just a minute. Let me retrieve this. It's talking about whether there's a direct conflict or whether conflict with the right, with the exclusive right, or the code is merely regulating how that right is to be enjoyed. That fine distinction.
Right, so firstly, let me start by saying I agree with absolutely everything Kim said. So she's looked at this from more of a sort of practical point of view. So allow me to sort of offer an academic point of view in answering this question. So when we talk about copyright, we're talking about a bundle of rights that come with owning property, much the same as a house, right? If you own a house, you are able to sell that house, you're able to rent it, you're able to, make a park in your backyard. You have a whole bunch of rights that come with that ownership. Copyright is the same thing. It's just ownership of an intangible thing. And the right to license is one of those ownership rights that come with being the copyright owner of content. And by limiting the ability to exclusively license that content, I think from an academic point of view, that it is beyond question that what the NBC code is doing is taking away from that ownership right. It's not regulating. Regulating the right would be, for example, saying that you're allowed to use content for educational purposes or private use. These are what we call in copyright fair use or fair dealing provisions, depending on your jurisdiction. Taking away from that ownership pie, taking a piece of that pie away, the licensing piece, by prohibiting exclusive licensing is logically and necessarily going to be taking away from that ownership right. And that is the problem. I think that's what is the common theme here, is that regulating is different from taking away. And what the code is doing is taking away.
Prof, do you have any thoughts on that? I mean, let me just put it in a different way. Do you have any thoughts on that? Is there anything wrong with NBC regulating how certain rights are supposed to be enjoyed? Is there anything particularly wrong with that?
Yes, I feel Income has said it. Jade, well done, they've said it all. Using the word merely does not reduce the strike or the effect of a thunderbolt. What will NCC do? Where is NCC in all of this regarding regulations, copyright, and exclusive rights? It remains overreaching. I feel they've gone beyond. And the only way they can go about this is negotiations. Sit with the stakeholders. Maybe you can negotiate something, do something. But how can you merely regulate how the right should be enjoyed? It's my right. It's my exclusive right to do with it as I want and all that. If you want to regulate, then call me, sit me down, let other stakeholders come in, and then decide on what to do and how to go forward. So yes, it is conflicting, and NCC is all about NCC as well. You can't take it out of copyright and say you put it into the Broadcast Commission without thinking about the bundle of rights Jade has talked about, and exclusivity, as Nkem has mentioned. They have exclusive rights. If you want something you can't sub-license on their behalf or force them. And the words that they use, compel. It's their private rights, it's their exclusive rights. Sit with them and negotiate, and it has to be for the public, not for any political reason.
Okay. For Jade, Prof, and Nkem, we're going to come to the issue of exceptions and limitations. You know, in IP, even the so-called private right or exclusive rights are not absolute. There are exceptions and limitations. So I'm going to come to that. But let me take the second question for Mr. Ayokere. In this question, there are two sets of questions for you, Mr. Ayokere. From your analysis and the discussion, you have to remove your jacket. This is interesting. We have spent over an hour already, and there are a lot of questions on the table. So let's roll with this. From your preceding analysis and discussion, supported by Mr. Emeka and Mr. Guy particularly, two sets of questions arise from the lens of competition law. First, from competition regulation perspective, restrictive agreements which you mentioned, monopoly, abuse of dominant position, including pricing, are important imperatives of competition law.
Yes.
The question here is, how do these imperatives fit into the exclusivity framework of the code? Now, the second context of this question is, should this be a subject of industry-specific competition regulation, which is what NBC has done, or within the remit of strict competition regime, because some have argued that it should be the role of FCCPC, not NBC. So in this context, they're asking you to try and reconcile general competition framework, which is within the remit of FCCPC, and industry-specific obligation, which is what NBC is doing. So what are your thoughts on this, please?
Fantastic. So I'll start with the second question first. It seems to be the easier one. And yes, I think that there's a role for NBC, and legitimately so. However, is there a time, is there a place where you cede overall competition regulation, even in an industry, exclusively to the industry? Probably not, because at the end of the day, the market regulation for competition needs to have some level of uniformity at a national stage, especially when you're engaging globally. And so, so just imagine if there were two undertakings within the media space that were looking to merge, and you say, well, you know what, NBC understands that space far more. Let them handle that merger. How would the global competition framework manage that process, especially if they're foreign to domestic or foreign to foreign relationships in that space? And then secondly, a competition regulator deals with a bunch of things, primarily law and economics. They're dealing a lot more with the consumers, whereas a sector regulator is balancing rights between operators and viewers. And many times they have a lot of technical knowledge about how that sector operates. But the market dynamics, typically that expertise would reside in a competition regulator. So there is absolutely the best model for doing this, which is a competition regulator that defers to the understanding of the sector by the sector regulator, and a sector regulator that in return defers to the expertise on market economics and market dynamics of the competition regulator. So somewhere in there, you'd always find the best approach to this. Now, with respect to the other question about the key elements of a competition framework and how that plays with exclusivity, and that is the question of restrictive agreements, monopolies, and abuse of dominant market power, because dominance in itself is not a problem.
Yes.
It's the abuse of dominance that becomes a problem. And I think it's very clear, and we've repeatedly said this, that the very nature of exclusivity itself invites competition scrutiny. But it's not blanket. It's not blanket. Sometimes exclusivity is what even promotes technology transfer, innovation, even fair pricing and quality. It depends. Sometimes you see a vertical integration in a value chain where it promotes efficiency. And to the extent that that efficiency would ultimately redound to the benefit of the market and the consumers, then it becomes an exception to some of these key elements or principles of competition. And I'll give you a quick example, which I just sent in an answer to someone here. My worry, and I understand where NBC is, and I'm sure they share that worry, and they're thinking ahead of how to deal with it. And so let's just use, since, the example that has become dominant in this discussion here is exclusivity in the licensing of a program, perhaps a sporting program. So just imagine my worry, a market entrant, a new market entrant who is willing to take the risk and is creative and innovative enough to go borrow a ton of money to acquire the license for a particular sporting program or event that drives subscription, and borrows itself to the very teeth just so that it can enter that market at a very high point and gather subscription. But now has to come and sublicense even that subscription, that right acquired, to a dominant market player who just takes a back seat and saves money. That new market entrant is operating on thin ice and may at best make money from reselling its rights, not by developing its market share. Now that's for us from a competition standpoint, buying and reselling, that's fine, but it doesn't impact the market in the sense, it doesn't impact the market enough. It might drive pricing in one, but it doesn't impact a sustainable market. If that new market entrant doesn't develop its subscription base in that cycle of that license and is unable to renew that license because it's some kind of an open bid and loses to another player, what is the sustainability of that business? So we have one new player who has become part of the study and the market dynamics, dropping out, changing the dynamics again, creating a headache for consumers, certainly a headache for the competition regulator. And so we'll look at the portal to portal, the entire value chain. And so ultimately, it's the theory of harm and the real benefit. And so our competition regulation is it's not a broad stroke painting. It's an analysis on a case by case situation. Now, would it mean that there will be no circumstances in which, as a competition regulator, we would determine that exclusivity in a particular situation will not benefit competition? As a matter of fact, will lessen or be a restraint? Of course. And when we get there, we would do that. But what we would be concerned about is where it's a rule to play and where the converse of that rule can be actually what creates what we're seeking to prevent.
Thank you. Thank you for that. Just before I come to Mr. Guy, there's a question for Mr. Guy. Just before that, I will ask Emeka this question. The question from Mr. Guy is how IBAN is going to respond while you're putting your thoughts together on that. There's a question here for Emeka, and the question is this. I will have to read it. There's been no discussion or mention yet of the elements of the code that speak to the blocking of airtime sales, which is the push to sort out the advertising lag for broadcasters. Is the NBC code not primarily about carriage deals? Is primarily not about carriage reads and not programs? I mean, do you have a thought on that question? Unmute.
Sorry guys.
Yes.
This question it's very important, and I think that again the role of a regulator seeks to especially the broadcasting regulator, if they step away and understand that the core of what they need to do is actually looking at the broadcasting market, and the broadcasting market consists of the broadcasters and the viewers, and what do they do? And then, of course, within that value chain is the content creators who creating programming gets viewers and expands the market. And in Nigeria, for very many years, that has not been the case. In fact, to put it quite bluntly, you have the biggest operator in Nigeria, SANS, the multi-choice platform, which is the public broadcasters platform, NTA, responsible for this inverted business model, which we've essentially turned the whole concept of television upside down, where a private independent content producer goes, spends his effort, creates content, goes to a broadcaster, buys airtime to show his content. There's no commissioning going on, and on top of that, even the revenue he makes from sponsorship or from airtime is often split with the broadcaster. So the broadcaster just sits just collecting rent. I mean, there's like a rentier economy. I have the license, therefore I can just pretty much do anything. And there's a problem there. So I think the NBC code in this instance tries to address that by putting or by limiting how broadcasters can and advertisers. But again, this is where I find fault with this. This is why I also say that it's an overreach. There was, you need to sit the broadcasters in a room, you need to sit the advertisers in a room, and you need to agree on a model. That's why it's called a code. A code is a code of practice. It is not something you, because you're a regulator, no matter how well-intended you are or you think you are, can do on your own. You have to bring all the parties and agree on a model which works best. And it's not a set of restrictions. In the marketplace that I talked about, there's so many alternatives today. There's people are getting this on YouTube. There's so many alternatives. We're in a digital media marketplace. The ecosystem is so wide and varied. So let's also understand that you have to make something work, especially something that has become a staple for many, many years in our market. You have to use carrot and stick. You have to have some incentives. There are no incentives in the entire piece of legislation with regards to, okay, so if you do this, if you advertise more local, let's use the example that Guy mentioned, where it puts if you bring a foreign content, you have to pay 30%. What is because it sounds good. I would like for people who spend money on foreign football or whatever to spend that equivalent amount of money on the local market here. But what is incentive? What is incentive? So there are no incentives. And that is the challenge. You do not get to the point of saying, oh, I'm simply going to, because it hasn't worked. And simply, it's just like saying, let me digress a little bit and saying Nigerian customs says, no smuggling of rice. But you and I know that rice is still being smuggled every day because there's a demand for it. So there's a demand side. There's a supply side. You need to take these two things into consideration. You simply don't say, oh, because we're the regulator, we are doing this. It won't work because you do not have the levers within your toolbox. Your regulatory toolbox doesn't just consist of a hammer. I often talk about it. Within that toolbox, there's something called a measurement. You must have the ability to measure what's going on. You must have like a spyglass to see what's going on. And you should also have the ability to have like a, what's that thing that French dusters, to dust some things off and say, this is, if you go this way, these are the incentives. And so I think that generally speaking, there has to be a rethink about the code. The intendment is beautiful, and I agree with that. But the process is where I find fault. And, if the process is not correct, no matter how beautiful the intent is, everything falls flat. Because now you have an overreach into advertising practice, you have an overreach into copyright practice, you have an overreach into competition issues, you have an overreach into, and all of those things. You're not a super regulator. If indeed if anyone should call themselves, it's the FCCPC. There's a super regulator, because by their mandates, they can, be in everybody's business, so to speak. So I think that the NBC needs to rethink, redesign this framework, establish definitions for what they intend to do. Because this, if you look at this whole code, it lacks definitions. Really, and as I said at the very beginning, anything you cannot adequately define, step away from trying to intervene. That's just my own point.
Okay, thank you. Mr. Guy, let me put this question a bit differently in a way that will not really put you on the spot. How should IBAN or the industry as a whole, how should they respond to the code?
Thank you very much, Prof, and thank you very much, Emeka. And I think what he always says, this regulatory deficit is probably an appropriate title for this program today, because that's what's been going on with this NBC code. The IBAN members, as I do know from talking to them collectively, they're not happy with it. It's almost becoming like a communist party, if you ask me, but I don't want to say that, but I just said it now. The first thing I want, Prof is laughing. The first thing about broadcasters, if we get the exclusive rights to a particular program and to drive traffic to a channel like Silverbird Television, if we get it, no matter what it is, so long it's premium and is exclusive, and now we have to settle with acquiring the rights from abroad, paying dollars, and then now going out, hey, Mr. X, you're sitting down in Akure and you need a program, I'll give it to you at 30% or whatever it is. First of all, we might not even have the privilege of sub-licensing it to another party. That's number one. Number two, where is the exclusivity in this whole thing? What NBC is trying to do is making us all the same. There'll be no exclusivity. What you see on Silverbird, you see on channels, on AIT, and et cetera, et cetera. There'll be no advantage in having any particular exclusive program because it's shared amongst everybody. What we're going to do, and we've tried to do right now, is discuss with the NBC. We've written a letter. IBAN has written a letter for them to call us for a roundtable meeting to discuss this further, because we find it very unfair. As we all know, the advertising revenue in Nigeria is dwindling to the lowest point possible. Now we have COVID. It's almost non-existent. And now we're forced to pay. We're now forced to share our exclusive rights. And then to make things worse, I didn't want to bring this, it's not part of the agenda. We now have hate speech which is undefined, which is unregulated. If I say something now, it's considered hate speech. Next minute, you're with DSS. Nobody knows what hate speech is. If I criticize, if a guest comes on the program to talk about something that's gone wrong in a particular part of the country, it's considered hate speech. Where do we draw the line? How do we survive as an industry? We have too many restrictions. What's going to happen is everyone's going to move to Canada. No one's going to stay in Nigeria again. That's happening. Thank you very much.
All right. Okay, back to the IP, because this IP issue is recurring, and I would like Jade to take the first shot at this issue, because you have done a lot of work on Marrakesh Treaty, which, of course, you know, deals with exceptions and limitations, and I want you to apply that principle, you know, even in this context. The point has been made about the conflict between IP rights and the prohibition of exclusivity, and the point has been made across board. Now, how can this be reconciled? That's one leg of the question. The second leg of the question is in view of the fact that these rights, these exclusive rights, are not necessarily absolute. In other words, there are exceptions to those rights, or even under copyright norm. So do we have this exclusive provision, this prohibition provisions, do they fall within these exceptions for them to be allowed or for them to be permissible under the existing dispensation?
So thank you very much for the question. I'm going to start with your second question first. So you're correct, right? No rights are absolute. Even the right to life is a qualified right. So no rights are absolute. There are exceptions and limitations to copyright. Those exceptions and limitations are usually justified as being in the public interest. So an example that I'd like to use, because I've been involved in it, is incorporating a disability exception, which would limit copyright exclusivity and the copyright ownership rights in favor of making content available to people who are disabled, for example, the visually impaired community. Now, in doing that, we are limiting that copyright bundle. We are taking away from it, but we're doing it in such a way that benefits society as a whole. It benefits the disabled community because they're able to become active in society. They're able to realize a host of human rights they're not otherwise able to realize in their lives. And it also benefits not just the copyright owner themselves, because they're now open to a new market of readership. It benefits society as a whole, because as we know, when minority groups, disabled people, when they're able to flourish, it's the whole of society that does well. So it's in the public interest to implement that sort of an exception. Now, this is different from the NBC code, because with the NBC code, what we're doing is we're taking away the primary source of income that many of these copyright owners have. And that is not in, or I would argue, it is not in the interest of the wider public. So let's take, for example, a sport like netball, right? So netball is one of the few sports in the world where there are more women who participate in it than men. Right, so it's furthering gender equality. Now, in South Africa, which, as I said, is considering similar regulations to Nigeria, Netball SA, the federation controlling netball in South Africa, have said that if they're not able to sell the exclusive broadcasting rights to their content, they won't be a viable entity anymore. And if they're not a viable entity anymore, what does that mean? Well, it means that a lot of women are going to be, predominantly women, are going to become unemployed. It means they're not going to have job creation, access to a livable wage. It means that communities which would not otherwise have access to opportunities are losing out on those opportunities. Another example can be the Paralympics. All these sorts of things feed into this scenario that we have here. And the same applies in the Nigeria entertainment and media industry. So PricewaterhouseCoopers, in their recent Outlook report, estimated that Nigeria's entertainment and media industry would be worth $10.3 billion by 2023. And they called it the world's fastest growing entertainment and media market. And that's obviously a conservative estimate. We know how accountants are. And a large part of that money is coming from exclusive licensing of these broadcasting rights. If the media industry loses out on this source of income, it's not just people directly involved in media industry who lose out, it's the wider Nigerian public who suffers. Fewer jobs created, less disposable income, less social mobility, and so on. And I really think that is the fundamental difference. Here, the public interest would not be to take away exclusive licensing rights. Copyright exclusions and exceptions, such as disability or access for education, those are in the broader public interest. Over here, the broader public interest is the opposite of what the NBC is arguing, right? And there are creative alternatives available. We can think about this more creatively. There's no need to see it as the sort of binary choice of two things. There is a good middle that we can come to by discussion, by conversation, by thinking creatively about these things. as other panelists have already mentioned. I've spoken so much now that I've forgotten the first question.
That's okay. That's okay, Jane. Okay, Inkem, you talked about one of the conditions that define the market under the code, compelling viewership and all of that. Can you speak to that in the context of exceptions and limitations? Because we know that these exclusive rights are not absolute. We know that even as IP lawyers. So how does this thing fit, this exclusivity debate, how does it fit into the non-absolute position of these rights under copyright law? Can you briefly speak to that?
Okay, well, in our law, under Section 11, which talks about exclusive license, the only the norm is that it must be in writing and it must satisfy the general rules as to contract, which includes proper execution, capacity, consideration, and the permissible limits of fairness. Beyond this, there's really no further requirements under the Act, under the Copyright Act. However, when we talk about compulsory balance of interests of right owners and the need to give society greater access to information and knowledge of materials, that is when this can come in. Yes, we can argue that it may be, but as we said, it must be taken on a case-by-case basis, just like it has been done in Europe. You cannot give a blanket a code to say it applies to all contracts and of owners of content to every of their possible ownership or licensing, exclusive licensing. It must be taken on a case-by-case basis. For example, in the UK, and Emeka talks about incentives. Incentives must be brought in. You cannot say you must do this without, okay, what is in it for me? You know, so in the UK, for example, when we talk about TV licensing is made free for people over 75. So these are the kind of greater society access, okay, or the balance of interest. You know, if we feel that it will help the people we are targeting, then yes, but it shouldn't be a blanket code over all types of licensing. That's my point.
Okay, you know, it's unbelievable how much time we have spent in this. We cannot take all the questions, but I'm going to give a shot to Prof on this issue if she has anything to add to Jade and Dr. Inkem. But we have to go one more round for your final thoughts on this issue, and then we'll round up this discussion. The questions are coming in and I can't take all of them, but there's a particular question also for Mr. Iwukere, which I think is very vital. I will take that after Prof can give an insight on this issue of conflict and the reconciling the absolute right. Do you have any additional thoughts on that before we go round for the final closing, the closing round?
Just briefly, again, they've said it all. Oh, yes, there are exceptions, there are limitations and stuff like that. What is built to do is study other laws. Look at what you have in the Copyright Act, competition laws, and every other area. There are actually ways in which they can use the Act to benefit themselves. But one thing is really very key. You need to sit with the copyright owners, broadcasters, film producers, whoever, to negotiate. You can't just tell them what to do with their rights. It's not done. And then you can't force them to sub-license or to license, but you can negotiate. I still maintain that you can sit down and come to a point whereby you say, okay, if you do this, like everybody just said, this will be what you get, or can we do this? Like they do in other jurisdictions. That's what I have to say.
Mr. Iwukere, very briefly, before we go to the final round, because competition, it's a big issue in this discussion. I think that's why you have a lot of questions coming your way. Further to your analysis, Section 104 of the FCCPA expressly provides that you have application to all industries You regulate all the industry. They are, all the industries are regulated within the purview of the FCCP. And Emeka is right on that, to use his word, super regulator, notwithstanding any other provision in any other law. I mean, that's what that section says very clearly. And it says that the provisions of FCCP shall override the provision of any other law. That's section 104 of your law. Subject to the provisions of the Constitution of the country, which is the supreme law, as we all know. Section 105 grants. Now, this is very interesting. Section 105, following Section 104 of your Act, grants concurrent jurisdiction on FCCPC and the relevant agency, in this case NBC, for example, with the right of precedence on FCCPC under Section 105. Now, the question is, does this suggest, or does this not suggest, the precedence of FCCPC on matters of competition regulation or objectives of the code? In fact, the Act encourages interagency agreement, which is your Act, regarding the application of competition regulation. Now, is there a vacuum here? And if so, how do you fill this vacuum in moving forward in the context of these specific provisions?
I think the law has filled the vacuum in many ways. And so what the law does is that it creates a concurrent jurisdiction between the FCCPC and the NBC. Rightly so. It's not hierarchical. The FCCPC is not superior to the NBC. And that's why we prefer to be superb regulators than super regulators. But what the law also says that with respect to competition law and consumer protection issues, the FCCPA, and so there's a distinction between the institution and the law. And so any conflict between any law and the FCCPA with respect to consumer protection or competition issues, in that case, the FCCPA would override. And the law is not erroneous, because if you look at Section 17A of the law, it actually says the FCCPC has the responsibility to enforce the provisions of the FCCPA and any other enactment whatsoever created, for the purpose of consumer protection and competition. And so that's why it's important that the law also says to everybody, including the FCCPC itself, that in carrying out your functions, you understand that with respect to consumer protection issues and competition issues, this law, the FCCPA, all other laws must be read in compliance with the FCCPA. So I don't think there's a vacuum. I think here we're debating this issue, which is good and is very vibrant. But I think when we get to a point where an enforcement issue or a compliance issue arises, we will all have to interpret the law or the gamut of all the laws in the manner that the National Assembly has structured the legislation to operate. And so for us, we participate every time in the discussions, but we know that they're discussions. And one of the things, because I'm a pretty lazy guy, I participate in conversations as much as I can, but I won't deal with a hypothetical problem. My desk is already stacked with real problems. And so I'm not dealing with hypothetical problems. I think that what this robust discussion does is to just give us all perspective. I suspect that when we get to a point where there is really a dispute with respect to how this will operate, I am sure that the law will take its course.
Excellent. Now, this is, we're going to the final round, the final thoughts of everybody, starting with Emeka. From all indications, this is for everybody in rounding up your thoughts. From all indications, we are right in the middle of one of the most important challenges of the rapidly developing media industry in Nigeria, which is that of course, as we all have agreed, regulation. with the huge investment in broadcasting, in infrastructures, in content development, in the new media, with the rise of streaming and much more. From where we are now, and with this code set before us, what is the way forward? Mr. Emeka, let's start from you. On mute.
I have to learn how to do this unmuting thing.
It's okay.
Yeah, so I mean, so my experience has always been that every regulator faces this, whether it's a superb regulator, a super regulator, a sector regulator, always facing this dilemma. How do you balance the need to employ regulations to achieve a purpose, and in achieving that purpose, maintain competition in your sector, protect consumers, but at the same time ensure that you protect and promote investment in the business. So it is a constantly that's a constant challenge. In regulatory economy, we call that the regulator's dilemma. But speaking specifically to broadcasting or to the media, as I said, and I'll repeat that again, we have this deficit of understanding of, even going back to this code, to make such far-reaching determinations as they've tried and restrictions that they've tried to do. There should have been a body of work, a report, a series of findings to support that conclusion. I don't know whether you understand what I mean. So was there a report to say declaring somebody a dominant operator? Was there a report to say these are the practices that we want to abhor? And you've actually clearly identified it. You've identified its impact, and therefore you've suggested interventions that will deal with that. It's kind of missing in this instance. And I think that's why I say that it is not so much, I see someone saying, or maybe, I think Professor Nkem talked about it, case by case. Case by case doesn't mean that you're dealing with it when Mr. A comes to Mr. B. No, it's actually segmenting what are the likely cases. Is it, for example, listing the national sports? You say broad national interests. What are those broad national interests? What are the broad, is it cohesion? Is it, what is it? And what are those, in the UK, they listed the sports all the way back to 1994, 96. And I've been involved in the first NBC code from 1996. And, so you define what those things are. It's sports. If it's sports, as I mentioned in the opening, is it local sports or is it foreign sports? And how beneficial are foreign sports is Arsenal and the Premier League to Nigerian cohesion? These are questions we need to answer. And in trying to answer it, I think we often try to shy away from questions that require rigor for us to really contemplate and really sink our teeth into the meat of the argument. But by and large, I know that the heart of the NBC is in a good place. I know that. I've worked there. I've known people there from its very foundation. I know that. But I think that there is a challenge, and the challenge is sitting in a position where you think that your primary duty and responsibility is to the government rather than to the market and to consumers and to the viewers. And the secondly is not having the right tool sets, or right understanding of how to put all those things together. And I think that that's the challenge. And Iban has spoken. I don't think, in my own view, there's enough consultation was done. If it was done, and I'll say this to conclude, we've had many codes. This is the sixth one in the past. There has never been this level of controversy around an NBC code ever before. And this is not the first time we faced issues around exclusivity. We had it in 96. We had it in 2000. We've had it, I'm telling you, because I've been involved in this business since the early 90s. So there's never been this controversy. But it kind of like shows you that there's something went on, something is not right, and it can be fixed. And I know the NBC can fix it. I just think that sometimes what is required of an industry is engagement. It's not sitting back and saying, oh, they've done it, they know best. They don't know best. It's when there's pushback and there's people go back and forth and finally come to the negotiating table and say, we need to look at this again. If there was an amendment after a year or less than a year after the main code was done, it means that there can subsequently be an amendment. Maybe it's a new tradition, but I believe that it can be. The problems or the deficits in the code can be looked at again and retweaked, and then we can probably arrive at a better scenario for the future.
Mr. Guy, what are your final thoughts on the way forward?
Thank you very much, and thank you very much, Emeka, for what you said earlier. First of all, I must say, NBC, as you know, is a regulator, strictly a regulator. They're part of the government to regulate and steer the ship for broadcasters. So suddenly, when they come up with punitive laws that affect broadcasters that pay license fees, exorbitant license fees for that matter, and we try to do our best to stay afloat. We try to drive traffic to generate our revenue, to keep our business afloat, and then we have the stifling codes that keep us, they basically stunt our growth. Not just us, it also affects the producers too. The most important thing is for NBC to call us to a roundtable, talk about these issues. We were never, and I repeat, we were never involved in this whole process. At least the most part of the majority of us. And they should encourage the industry and not stifle the media owners or the producers or the music label owners. We are the reason we have a regulator. And without us, NBC has no business. So we need to work together. Thank you very much.
Mr. Arukera, I mean, you've spoken so much for want of repeating yourself. Can you give us your final thoughts? Should NBC have sat down and do nothing? This whole industry is very dynamic, as we have learned. Should they have sat down and do nothing in the light of these very crucial issues that are before both the regulator and the industry? And because of time factor also, because something has to be done urgently. So should they have sat down and do nothing about this? Don't you think that this can also be a strategy to invite a whole lot of discussions and debate and all of that? And you know what I mean? So what are your final thoughts on the way forward?
I mean, so my final thoughts is that first, I actually commend NBC. It's, you know, having been a regulator for a few years now and seeing the scope of and the depth of business, their power, their leverage, the skills they have available to them, compared sometimes to what we have in government, it's courageous for NBC to take on what they've done, and that courage, I commend them for it. And so here we are. We've got broad provisions in the regulatory framework that address a lot of things, but because of what we have a dispute with, because of what there's a contention about, we're not really focusing on the clarity it brings in all the other areas. And it's not unusual that a regulatory process would always bring some tight issues, but here we are, we're all discussing it. And so here we are, we're about to make it even better. And so I think that by all means, I credit NBC very much. And regulators, I mean, the worldwide approach for regulatory frameworks, regulators will always interpret their powers broadly. It is the system, especially the judicial system, that ultimately narrows it down. Anywhere in the world, we can complain about it. We can say regulators in Nigeria want to destroy business. Regulators in the United States and everywhere always interpret their powers broadly. And the regulatory process, the challenges, judicial decisions, and all of that ultimately clarify and narrow it. And so I don't think NBC has done anything inappropriate. Can we say that they should have consulted more? Of course. But if they consulted more, we'd still have the same outcome. We'd still say they could have consulted more. There's no question about that. But like I said, what I now think is what Mr. Mba has said. And that's one of the things I take away from a regulatory standpoint. And that is that being feared is different from being regarded as a regulator. And being regarded requires that you can engage and that the industry or the people you regulate can come straight to the table. You can give them the benefit of the doubt, but beyond that, credit their expertise and knowledge of the industry also, and make sure you take it on. And I have absolutely no doubt that NBC will do that. And to the extent that we're required at the table to discuss consumer protection and competition, we will be there with industry, with NBC. But I think that this is an important step. And I'll close by saying that what even underscores how important this step is I can say to you that from a consumer protection and a competition standpoint, this industry is one of our headaches, especially in recent times. And you might ask that, what do you mean? It's, for an industry, just look at the number of people who are subscribed and compare it to the number of people who use banking, electricity, or telecommunications. And then look at the intensity of the dissatisfaction. And then when you scale that up, and so if you have 1 million subscribers in pay TV, for instance, and you're doing what? 300,000 complaints, whether it's pricing or services, whatever you want to call it, and you have 10 million subscribers in telephone, and you're doing 1 million complaints, it tells you, there's a bigger problem in one than the other, even though the complaints or the dissatisfaction is not, the number is not as high. And so I welcome this conversation. I think where this bird will ultimately land will be vital to addressing abuse of dominant power and market entry. That's where we need to go. Make it easy for others to enter the market, make it possible for them to sustain in the market. And for one thing, I have been against some exclusivity anyway. For instance, I think things like CNN, BBC, those are news channels. There are constitutional provisions about access when it comes to things like news. And if you have developed a brand all over the world, that makes it important that anybody you partner with locally would own the space. Then it is important that we as regulators must look and say that we want many people to be able to operate in that space. Now, for other things where there are open bids and all of that, and then global relationships that are based on that exclusivity, then yes, I think that we can begin to look at that. But I am even more concerned about vertical arrangements within the industry. I was hoping that one of the things I would hear is where a broadcaster also is a producer or financing the production of movies or content, and how others can have access to that content. Whether that broadcaster can say, look, I invested in developing this space. Now it has become what everybody wants to watch. And I don't want to use examples, but there are homegrown drama channels now that are gold standard across the continent. And so should other services be able to have access to that on fair terms? Those are some of the key things that I am interested in, not so much as when we're all different and we're going to license from some independent content provider by themselves. I'm more interested in when you have developed the leverage and the power to develop content because the market had not developed. It's almost the same thing with the distribution networks we have. So because of our bad roads and everything, and so you have a company that is dominant in a business and has also now owns the distribution network for that business. Can other companies piggyback on that distribution network, or would they produce and just stand at the side of the road? So those are some of the key issues that I think as we unlock. And one of the things I've also found out within industries is that there's some things that are absolutely uncontested. Let's go unlock those ones. Let's unlock the ones that are uncontested and let the market correct itself while we address the ones that are subject to serious contention. Thank you very much.
Excellent. Excellent. Thank you. Jade, what are your final thoughts on the way forward? I mean, what are the lessons? What do you consider as the best practice, the best global practice? And what lessons might be applied from other jurisdictions in Nigeria as a way of giving us your final thoughts?
So I think that the symmetries that can be drawn between, in particular, South Africa and Nigeria, those two experiences, is the desire for the global South to feel better represented in international IP conversations in the international IP arena. So there's a growing body of work by academics, and I include myself in that, who argue for greater flexibility in international IP standards pertaining to the global south. And this discontent with the historical status quo is, I think, definitely a justifiable one, and it's a concern that is at least in part evidenced in these discussions that we're having. That said, it's my opinion that the Nigerian code is itself the very thing that it criticizes from an international standpoint. It is inflexible, it is undemocratic, it is rigid, it is all of those things which we've all spoken about. And it also, as Nkem spoke about, raises some fundamental concerns, not just from an IP perspective, but from a wider rule of law perspective. For example, limiting IP exclusivity according to compelling viewership of a program by Nigerians, but not saying what compelling viewership means, which is alarming from a rule of law perspective. It's unclear, nobody knows what it means, and if we're using it to justify taking away someone or an entity's proprietary rights, uncertainty is a very troubling thing. Uncertainty amongst rights owners and broadcasters alike is never going to yield economic success. And I think that it's really important to remember that the justifications for granting IP exclusivity has always in the history of intellectual property, if we go as far back to the dead guys who had stuff to say, like we talk about Jeremy Bentham, or we talk about John Locke, all of these ancient people have always justified IP exclusivity on the understanding that this will, when effectively regulated, reap benefits for the wider community, for the wider Nigerian community, the wider South African community. That is what justifies this exclusivity. It's not just, some fat cat sitting with exclusivity getting rich off the people. It's the idea that the exclusivity itself will benefit not just the individual, though it surely will, but the community as a large. So the narrative which both South Africa and Nigeria, in terms of their regulations, seem to have adopted to some degree, of there being either this IP exclusivity monopoly that exists on the one hand, or absolutely no exclusivity at all on the other in terms of broadcasting, is, in my opinion, a false narrative. There is a middle ground, and I think that a more creative exploration of various options that are available in regulating exclusive licensings would be a preferred way forward, instead of simply saying we're doing away with exclusive licenses and undermining all of the benefits, the societal benefits that exclusivity brings with it, not just for the rights holders, but for the country as a whole. Excellent,
excellent. Dr. Nkem, what are your final thoughts on this?
Thank you, Prof.
What are your recommendations? As scholars, we usually have recommendations at the end of every discussion. So what are your recommendations and the way forward?
Okay, thank you very much, Prof. Well, I will say that we agree that every country determines their own approach to the application of competition law. However, it is my submission that in applications of these type of regulatory principles, it should be done in a manner that takes cognizance of their unique developmental stage. Now, if windowing encourages and stimulates the movie industry in terms of movies produced and higher earnings in terms of licensing fees paid to movie producers and performers by extension, should the regulatory environment not take cognizance of these benefits? The question is whether outright prohibition of windowing takes cognizance of Nigerians' developmental stage, especially in the creative sector. Now, my recommendation is that we should address the maximum period or the minimum period of time of exclusivity. I really encourage and hope that the entire Nigerian's creative industry should unite and engage the government early on to prevent stifling regulations. Thank you.
Prof, you have this task of tying all this together for us. Yes, can you do this in?
I believe we're all on the same page with different perspectives. Yes, NBC should be commended for the bold step. It's not about what they've done; it's how they've done it, and it can be rectified. Like he mentioned, it's not the whole code, but some parts of it need to be looked at again. So nobody's saying you shouldn't have done what you did, but in some areas, how you've done it, looking at language, one, language, and then two, Mr. Guy still mentioned that they weren't involved in the process. Make stakeholders, get them involved in the process. Prof, we all know IP is about monopoly and exclusive rights. I don't think IP I think actually it enables competition. Start your own market of your own in the same industry and move on. Nobody is saying you can't be in the same industry, but the fact still remains that IP is about monopoly, is about exclusive rights and all that. You have copyright law, you have competition law, you have other areas of law, and that is IP. And I don't think at the end of the day, it actually stifles competition. I actually think it enables competition in any market. So we have to adopt a Nigeria-centric paradigm. There's an Afrocentric, Eurocentric, Nigeria-centric paradigm in dealing with what is within our environment and how best to deal with the matter. If we look at other codes and other jurisdictions, we have to make it suitable for Nigeria to grow, and everyone should be taken into consideration. Thank you.
Thank you very much. I think we have very important takeaways in this discussion. This has been a very, very robust and insightful discussion. I know that adopting Jade's terminology, there is a middle ground. We're not particularly going for the two extremes. There is a middle ground. We have a takeaway of consultation. There's a need for consultation moving forward. And Mr. Irukere has really mentioned two key competition principles that should be focused on, which is the abuse of dominant position and market entry specifically. Those are very, very germane in moving forward in this. And it's important to also state that there is no fundamental inconsistency between protection of IP rights and competition. Really, there is none. There must be some kind of middle ground or reconciliation of these objectives in moving forward. And I think that is something that that forms the takeaway in this discussion. And I will hand over to my boss and my hosts of this discussion to give us the vote of thanks.
Wow, that was interesting. And Prof, please stop calling me your boss. You're my boss. I'm really, really grateful for all of you for turning up. Guy, thank you so much for coming. I know it wasn't easy getting you to attend, but I'm glad you accepted. My classmate, Mr. Tunde, I'm sure I don't know if you remember, but we are classmates from law school. So I'm very proud. You've done our set you've done our set justice. I mean, it was very impressive. I'm very glad you came on board. In fact, it was a key, it's very important that we had you on board because you brought out clarity in certain areas, especially when it comes to competition. Jade, thank you so much. It was brilliant. I'd like to talk to you a bit more. There are one or two things you brought up that I think I need to have a one-on-one with you. Inkem, same thing. Thank you so much for honoring us. And my old friend, Emeka, thank you very, very much. I mean, we discussed before now, and I can see that, yes, you are a master in that broadcast area. Thank you so much for coming. And then my profs, my partners, Yemi and Bambo, thank you as well. This is the third series of our IPR talks. We're hoping to continue if we can. That's if Yemi and Bambo will be ready to continue. She's already frowning, but we've done three. We've been having calls for collective administration, which is another good area that I think we need to talk about. We've done something on publishing. So hopefully maybe next month we'll see some of you again, and we hope that the People that attended, we thank you. Some of you have been attending for the last few sessions. We hope you would come back. And we'll keep sending you updates on what we're going to do. Thank you so very much. There's still a lot to discuss on this code, but I think we've made headway. And I've had contact with the NBC, and I know they listen, so I don't think there's a problem. I'm sure this is going to be talked with directly with them, and we're going to discuss this directly with them. Thank you very much, everyone, and hopefully see you next month at another webinar.
Thank you.
Hi, Tunde.
Everyone.